Thank you everyone for being here. I think we have quite a few people joining, and I know that we're recording this webinar so that we can share it with people who weren't able to attend who wanted to. My name is Rachel Hackstema and I work with End of Life Washington. And I'm going to hand it over to Judy to do the official welcome and introduction for this webinar.
Good. Thanks so much, Rachel, and good afternoon. Welcome, everyone. How many people do we have on the call at this time, on the webinar at this time?
25 or so right now.
Okay, well, I'll talk and we'll keep welcoming people as people arrive. So good afternoon. Welcome to the Ames v. DEA, a webinar and fundraiser to allow psilocybin therapy for patients with advanced illness. This is just a wonderful opportunity to hear directly from Dr. Agarwal from the Ames Institute, as well as his lead counsel, Catherine Tucker from the Emerge Law Group. I'm Judy Kinney, End of Life Washington Executive Director and your host this afternoon. So after a brief introduction and some housekeeping, we will explore with our guests why it is essential that we take action on psilocybin access now. This is a legal process to open up access to psilocybin using the right to try laws. And why psilocybin is a good choice for many terminally ill individuals and how increasing access will benefit even more people. So after I interview Catherine and Sunil, we'll provide both a time for you to support this cause financially, as well as to ask our guests questions that you may have. Briefly, you may know End of Life Washington as a nationally recognized leader in advancing terminally ill Washingtonians' right to a full range of end-of-life choices, including death with dignity, through support, advocacy, and education, as well as the organization that Washingtonians look to advance end-of-life choices in our state. Because we advocate for terminally ill individuals to have the right of a full range of treatment modalities for both their emotional and their physical care, in September of 2020, so coming up on a year ago, the Board of Directors approved a policy supporting psilocybin-assisted psychotherapy as a legal option as a part of palliative care for terminally ill patients. And in May of this year, we submitted a powerful amicus brief in support of this very law that this lawsuit that we're discussing today, the Ames v. DEA lawsuit, now before the Ninth Circuit Court. You can search psilocybin on our website, endoflifelaw.org, to find both of these documents. Now, though, let me turn this back to Rachel, our community outreach coordinator, to walk you through a few housekeeping items.
Thanks, Judy. So thank you everyone for being here. As we mentioned, we are recording, and I think you got that message. So just letting you know that. Secondly, I just wanted to say that if you have questions for our panelists, for Catherine and for Sunil, there is a Q&A option. It should be in the lower part of your Zoom window with a little speech bubbles. And so you feel free to put questions into there, and those will come to our team, and we'll and try to get to as many questions as we can after each speaker, a few questions perhaps, and then at the end, some additional time for questions. So feel free to use that box or the chat box, but the Q&A box works well. And then do chat to the hosts if you do have other questions. And welcome to Sunil Agarwal. Thank you for being here. So we're just getting started. If you need help with anything, feel free to chat to the hosts and use the Q&A box, and we'll turn it over to Judy to begin the webinar by interviewing Catherine Tucker on this exciting topic. Thank you.
That's good. Thank you so much. Yeah, we want to be thoughtful of everyone's time and really give as much time to our guests as possible. Catherine, it's so wonderful to have you here this afternoon, and I'm so glad that, given your experience, that you are a key force in this cause. And just let me just provide just a bit of an introduction. Catherine is a special counsel and co-chair of psychedelic practice group at Emerge Law Group, as well as the past executive director of End of Life Liberty Project, the Disability Rights Legal Center, legal and advocacy director for Compassion and Choices. She teaches law, medicine, and ethics at the End of Life at leading law schools and has served as a campaign counsel for Washington's first Death with Dignity initiative campaign in 1991, and went on to represent the patient and physician plaintiffs in Glucksberg et al. V. Washington and Quill et al. V. New York. She argued Glucksberg in the Supreme Court of the United States, where recently Catherine has work has evolved towards advocacy to open access for psilocybin therapy as a palliative care tool, including involvement with successful campaign in Oregon to enact the nation's psilocybin therapy law, and currently, as we're discussing today, in litigation to compel the DEA to allow access under the state and federal right to try laws. Catherine, thank you so much. You are the person to be here to talk to us about psilocybin access and why it is really important to take action on psilocybin access now.
Yeah, well, thanks, Judy, so much for having me. And now everyone knows how very old I am. And, you know, my relationship with End of Life Choices Washington goes all the way back to 1990, when I was campaign counsel for the first Death with Dignity initiative measure in the country. And that was a great honor. I was very young at the time. And as you know, that measure didn't pass, but it did years later. And the Oregon measure passed as the nation's first Death with Dignity law in 1994. And I was so interested in the intersection of law and medicine at the end of life after working on that campaign that I've stayed in that field really my entire career. And recently, I have somewhat surprisingly found myself in advocacy to open access to psilocybin therapy because of the promise it shows. And I'm glad Sunil, Dr. Agarwal is here to also talk from the doctor and the clinician perspective about what that promise is for patients. But as an attorney and an advocate for patients facing end-of-life issues, the promise as reflected in the studies that have been coming out in recent years from leading institutions, including Johns Hopkins, UCLA, NYU, have been really exciting because they show immediate, sustained, enduring relief of non-physical suffering. And so that's been something of a gap in the palliative care toolbox. Over the many years that I've been doing the different kinds of advocacy I've been doing, and it's been quite a wide range, I would say we've seen really big steps and strides to improving end-of-life care. And that's a great thing. We've done a lot to make sure that patients are able to receive attentive and aggressive pain and symptom management, and that they know about and can enroll in hospice for comprehensive palliative care, and that they have more choices available, including palliative sedation and aid in dying. And so all of this is good, but the gap that was notable was therapy to address non-physical suffering,
Right.
anxiety and depression, and that's what psilocybin therapy addresses. And so the modern day research with psilocybin has shown it remarkably safe and effective in resolving those conditions. And so I wanted to get busy engaging advocacy to open access. Those substances all sit on Schedule 1 of the Federal Controlled Substances Act, so they're not available. They are prohibited. But I did hit upon an avenue that could open access in this right to try work. And basically, what that is the recognition that dying patients don't have the time to wait for the long, slow
Right.
process of new drug approval, which can take a very long time.
Yeah.
And so if a drug has entered that process and cleared phase 1 clinical trials and remains under investigation, that drug is to be available for patients with serious and advanced illness if their physician thinks it could be beneficial, if the patient understands it's an investigational drug and is willing to sign an informed consent reflecting that. And psilocybin fits those criteria.
Mm-hmm.
And so when I became aware of psilocybin as possibly an eligible investigational drug,
Mm-hmm.
I was excited about that as offering a sooner avenue to access, and hence began my discussions with Dr. Agarwal, who, of course, already has an array of palliative care tools that he is able to use with his patients, but has been keenly interested in psilocybin therapy and following those studies and wanting to be able to offer it to his patients. So with Dr. Agarwal and a number of his patients, I began to reach out to the DEA and inquire how it would accommodate the right to try. And, for your viewers who don't know about right to try, this is statutes that have been enacted at both the state and federal level. So Washington State in 2017 adopted by unanimous vote of all Washington legislators its own state version. And the federal government, the federal Congress adopted the federal right to try the next year in 2018. So with these two laws supporting our claim, we went to the DEA and asked how it would allow Dr. Agarwal access. And the DEA rejected any access other than research access, which of course is very different than therapeutic use.
Right.
So that rejection opened the courthouse door to the filing of a case, which is now pending in the Ninth Circuit, known as Ames versus DEA. And so that case now brings to the court the question of, must DEA, which is a federal law enforcement agency with a broad but limited role in law enforcement around controlled substances, whether the DEA must accommodate RTT. And of course, the lawsuit, for the lawyers on the call, raises a lot of extremely interesting issues about, what is the reach of the Controlled Substances Act? What is the reach of the DEA authority as the agency vested with authority to implement the Controlled Substances Act? And what's the limit of that authority? And then what is the interface of state and federal law and responsibility around regulation of the practice of medicine, which many on this call who are interested in the death with dignity statutes will remember was the focal point of a case that I was involved with that went to the United States Supreme Court around an effort by the DEA to nullify the Oregon Death with Dignity Act using the Federal Controlled Substances Act. And we, on behalf of terminally ill Oregonians, stood up and said, that's not permissible. And the state of Oregon joined that case as well and said, it is the state that regulates the practice of medicine. And that case, which is now quite a famous case in the law books, went through all levels of the federal court. And at every level, the courts respected the right of the states to be the primary regulators. So that's an important precedent here. Mm-hmm. And it falls under the broad label of federalism. So there are federalism issues in this case, and a whole host of other really interesting issues.
Right. So it has national implications. It also, legally, it does for care. I know I got really excited about psilocybin last summer and early fall, just for us as an organization and other end-of-life organizations, as you say, to really take on non-physical suffering. just feels like a really essential part of our approach to end-of-life choices. So thanks. And Catherine, I'm concerned that you may be frozen and I may be.
Yeah, well, and particularly where.
Go ahead. Sorry, I think you're frozen, but we can hear you.
Okay.
We can hear you well. Yeah.
Say particularly where we allow patients.
There you go.
Can you hear me now?
Yes.
Okay, I was going to say particularly where we allow patients to choose the option of aid in dying. You know, surely no one wants to imagine that a patient would be choosing to advance the time of death because they have unrelieved suffering.
Mm-hmm.
We don't know if psilocybin therapy might impact a patient's choice among the various end-of-life choices.
Mm-hmm.
There are certainly some palliative care physicians who believe that psilocybin therapy could reduce or eliminate patient interest in aid in dying. There's no data bearing on that, but certainly we would all celebrate if no terminally ill patient had unresolved anxiety or depression.
Right. And really, this is about the law supporting patient-centered care. So to do research and the length of time that takes is a privilege that terminally ill, dying people do not have. So I'm really excited that both you and Sunil and others that are involved with this are really working to advance this. And that's why we're here helping to raise money for this cause. So we're really thankful for your work. Will you say a little bit more about where you did a broad overview of the law and the implications? Can you give us an update where the lawsuit is and just a sense of timeline about what's coming ahead and why this matters and where we are in the process? I know you're living and breathing it.
Yeah. Well, so lawsuits typically move like glaciers. They're very slow. However, we've done some things to expedite this case that have been successful. And so this case for a federal litigation has moved shockingly fast. And I know for the patients and maybe for Dr. Agarwal, it feels slow, but in the perspective of federal litigation, it's moved really fast.
Mm-hmm.
A couple of things that have enabled it to move as quickly as it has is we filed our case in March. We had a direct review to the Ninth Circuit, which for the non-lawyers means we didn't have to go first to federal district court and then pursue an appellate level review in the Ninth Circuit. We went straight due to a federal jurisdictional statute governing review of agency action. We went straight to the Ninth Circuit. So that was one fast step. We also filed a motion to expedite in respect of the reality that Dr. Agarwal's patients have advanced illness. And that motion was granted. So we had an accelerated briefing and argument schedule. So all of the briefing has been concluded now as of about a week or so ago. All of the briefs for the legal eagles on the call or any who want to drill down into the knit of the legal arguments, I have on the Emerge Law Group website on the blog, I've blogged about the pleadings with the links to all the underlying briefing. And it is voluminous. So feel free to access that. But all the briefing is complete. The case has been set on an accelerated schedule for oral argument on September 2nd, which is just incredibly fast. So that's the next big event. The Ninth Circuit now live streams all oral argument and it records. So you can either watch it the day of, you could host a watch party, or people can see it in the recorded version the following day. Sometimes at the court, the questions of the judges might suggest some insight into how they're leaning. And so people that are close to the case eagerly watch for those signals. And then you just wait patiently for the court to issue its ruling. The Ninth Circuit hears cases before 3-judge panels. So an exciting thing that will happen before the argument is the identity of those judges will be made public. And then also some like to try to speculate whether that's a judge that would be favorable to the issue at hand. So that will be known about 10 days before the argument. And then of course the argument is exciting, but then the big news is the decision. And I guess one thing, to keep in mind, we are challenging federal agency action. And so that's always a tough go. A win for the petitioners would be what I'll refer to as vacate and remand. That would be the biggest win that we can hope for, where the court would say, the agency decision to refuse therapeutic access, it must be vacated. And the case is remanded to the DEA, meaning it will be sent back to the federal agency to do a better job at responding to our request for accommodation. So it's not as if a win will be the court ordering allowance of access. And that's an important thing. I want to manage everyone's expectations. A vacate and remand sends it back to the agency. Now, we've hoped, and one of our amici has outlined what the DEA could do on remand, and petitioners think that suggestion is quite good. And the suggestion was essentially that a clinician like Dr. Agarwal would submit a request to the DEA for RTT therapeutic access, and that clinician would identify that he's licensed, that he will receive the substance in a controlled setting and keep it secure so that concerns about diversion and theft are not concerning, and so forth, that the physician treats patients with terminal and advanced illness, that will be used with those patients, that those patients will have filled out the informed consent, just kind of ticking through a list of reasonable things that would take Dr. Agarwal, 5 or 10 minutes to submit to DEA. And then DEA would either issue an approval, or if 7 days had gone by and it hadn't responded, that would be sufficient for then Dr. Agarwal to go to the manufacturer and show the application, and the manufacturer could then supply. So something like that would be an acceptable and reasonable outcome.
Thanks for sharing that with us. And so just in a summary for the non-lawyers in the group, this is, I would say, precedent setting for non-physical care for folks that are terminally ill folks. That really, I think where I got excited about this is Washingtonians and in End of Life Washington, we do like to be on the leading edge of end of life choices. That's our reputation. That's who we want to be. When I think of this, I can't think of anyone else but you or Dr. Agarwal to play this role, to make these precedent-setting changes. So I want to thank you. And I'm going to say this in multiple ways a couple times, is that all this is great and lovely. We can see how powerful the potential here. I would say even without a win, I think it's still precedent setting because we're always moving law forward and expectations forward. And that this, is my understanding, is funded by donors, like individual donors. Like this is why we're doing this as a fundraiser, is that it takes all of us really to create this movement. So thank you so much, Catherine. And we're going to open up for questions in a bit. And just for the sake of time, I want to transition over to Dr. Agarwal, but I want to make sure that people understand why we're doing this as as a fundraiser in particular, is that everyone loves precedent, everyone loves, we're all here for end-of-life choices, and we all have a role in making that happen. So we're not attorneys, we're not involved in that way, but we all have a role in helping ensure that psilocybin access through right to try laws are advanced. So thank you so much.
Yeah, I mean, just in closure there on that, I'll say I certainly wasn't going to expect Dr. Agarwal or his patients to be paying lawyers' fees. Their contribution to this case is bringing the issue forward, as they've done ably. But this is a public interest litigation with the goal of benefiting patients across the country who have serious and advanced illness. And so that's the population that stands to potentially benefit.
Good. Thank you so much. So Dr. Agarwal, we're going to transition to you now, and really glad that you're also just someone I've come to know as being on the leading edge of end-of-life care and well-being for individuals. So for those who aren't aware, Dr. Agarwal is a board-certified physician in hospice and palliative medicine and physical medicine and rehabilitation, and also a medical geographer, and serves as the past chair of the American Academy of Hospice and Palliative Medicine, Integrated Medicine Special Interest Group, and an inaugural member of the Safe Use in Psychedelic Assisted Therapies Forum. He was recently named as a top 20 emerging leader by the AAHPM mentioned previously. He is an affiliate assistant clinical professor of rehabilitation medicine at University of Washington School of Medicine, an affiliate assistant professor in the Department of Geography, and an affiliate clinical faculty with Bastyr University. He completed his MD and PhD degrees at University of Washington, and is the co-founder, co-director, and practitioner at the Ames Institute in Seattle, a multi-specialty teaching clinic and research institute, offering cutting-edge care in oncology, psychiatry, neurology, rehabilitation, pain, and palliative care. And he's also serves as an associate hospice medicine director, on-call palliative physician of multi-care health system, and recently joined the End of Life Washington Board of Directors. Again, I can't think of two other people who are more perfect for this moment to help advance this cause. Dr. Agarwal, welcome.
Thank you.
It's great,
introduction, Judy, and it's great to be with you, Catherine, and with the rest of the panel and those who are tuning in. Thank you for your interest in my patients' cases, which we have brought into the court, I thought I'd share a little bit about these particular patients, but of course with the idea that their circumstances could be broadly applicable should we challenge this particular interpretation, especially to be successful in our challenging of this interpretation of the law that we ran into from the DEA standpoint. So how it is I have patients that there's two patients in particular, and there was many such patients that I can tell you that I've treated over the years and who are in my clinical practice that would meet qualifications under the right to try law for experimental therapeutic use of treatments that are in early stage clinical trial development and who have life-threatening illness. It's just that it comes up so often, psilocybin and psychedelic therapies and psilocybin, because of the rising interest in relationship to these major studies and popular press books and films and so on. I mean, it's really a rising tide, and so many patients and their families are are learning about this. Maybe they've heard about it dimly before, but now it's really in the mainstream, in the zeitgeist. But you know, there's always barriers to doing a right to try case in a place where there's no ground, new ground, and those patients really need to be able to be in that for the long haul. They need to be willing to, be willing to potentially have some aspect of their medical and private health history, made public. And so it takes a certain type of patient, and I really just admire and respect greatly these two patients that I did sort of select based on those criteria, and both of whom, were no strangers to, had already told me that they were really interested in legal changes, improving accessibility to a wider swath of patient population for treatments that they wanted to pursue. And both of them had already explored. So these are patients with advanced cancer. Let me just start saying that. These are patients who are struggling with various stages of serious illness, mostly stage 3, stage 4, or with high markers that increase the mortality risk in one case. So we have breast cancer stage 4 and triple negative breast cancer, which is a highly advanced cancer scenario in breast cancer in particular, which means that there's the typical hormone therapies we use to try to slow the cancer are not able to be used. And then the others is a recurrent ovarian cancer with BRCA positivity, which is these genes that were discovered by Dr. Mary Claire King, who's actually one of my associate directors at the University of Washington MD PhD program that I went through. She worked very diligently to isolate these genes that cause increased risk factors in families for breast and ovarian cancer. And for many years, people never even believed that such a thing existed. And interestingly enough, that actually went to high federal courts as well, because a company wanted to patent the testing of those genes for patients, and a company called Myriad. Anyway, point is, if you have those genes and you have ovarian cancer or breast cancer, your risk of recurrence and mortality goes up. So this patient has that. So anyway, these two patients in particular, had been struggling with pain and existential distress, demoralization, hopelessness, different shades of anxiety and depression related to their cancer diagnosis, in their middle ages. So I had tried to treat them with ketamine-assisted psychotherapy, which is another emerging therapy that we can access. It's a Schedule 3 substance. We're using it off-labelly, but there's lots of promising data there as well. And so they really did get some improvements, but nothing like the needle movement that you're seeing in the studies with psilocybin for these kind of patients is really impressive, long-standing benefits. It's a much longer therapeutic duration of effect and potentially after effect. So it really is kind of a big step, and that's where we wanted. It was natural for them to really get prescribed that therapy. I wanted to prescribe it for them, or recommend it, or authorize it under the right to try law. And Catherine thankfully got in touch with me, thanks to End of Life Washington, really putting us back in touch again after many years. And I just happened to be at the right place and right time to be able to work on that. And so these patients, I did the steps necessary under the state laws, under the federal laws, and then we ran into this roadblock. And I think that's really where this, now it's a legal matter. But the medical matter, the medical issue, it's still present, with these the patients, their diagnoses, they're working through these conditions. The good news is that the court did say, hey, okay, you have an expedited need because of the unique medical circumstances of the petitioners. So we'll make sure to get to you as soon as we can, which I'm grateful of. And so much has transpired since they accepted the case a few months ago. It's remarkable to me how fast things have rolled out. both, the opening suit that Catherine and her team of amazing lawyers put together, and then the amicus briefs of so many agencies, organizations, and nonprofits, for-profits, academics, law professors, think tanks, you name it. I mean, attorney generals, so government officials. I mean, it's quite a constellation, and I can tell you, the patients were extremely gratified to experience that level of support for their healing, and of course for what their healing would represent. That sort of, I think, has put a lot of wind in our sails. And then, of course, we saw the government's first time that they've responded on anything in writing since the time that the DEA denied denied us this path. And it really is it feels to me like we are, it's a clash of world views. Is there a world in which the DEA can understand their limits and the emerging medical therapies that they are also, congressionally dealing with? I mean, that's sort of they sort of don't. They are sticking to that old model. And I mean, a lot of my work and studies over the years has been at understanding the development of the current regulatory schema we have with these substances, through really going back to the first time these substances became of interest to authorities, which Western authorities, which actually is it's called the early post-Columbus contact in the West, if you really want to go back, because there's records from early days of Spanish missionaries. And in those days, the authorities were not doctors or medical agencies, but it was the church and what the church felt about these type of therapies, because these therapies are unique in that they have a special spiritual health involved axis of therapy. So they have been involved both in sort of the medical or healing world and the religious world, you can say. And there's sort of a nexus there. But all that sort of prejudice that sort of they were colored with, even in those early 1600s, really kept on in various ways into the founding of the country and beyond, into the treatment of healing practices with that indigenous people use with psychedelic substances. And it's only in the latter part of the 20th century that we started to change some of those laws. And I think the laws that the DEA is citing come from the 70s, 1971, and everyone knows, it's very clear on the record how those laws that were developed were very much politically motivated, and by the Nixon era politics.
Right.
So that's some of the history that I understand, and I think the DEA is operating from that rule book.
Right.
And so what's really nice is that there is a legal pathway that is coming out, that the right to try law is our. So let me say a little bit about that, because I think what's happening is a new emerging public health framework in the country, a new public health approach to patients with serious life-threatening illness, end-of-life care needs. And thanks to the efforts of Catherine and many others before in the field of hospice and palliative medicine and the founding of those fields, many others in the work of what's called advanced directives, advanced care planning, medical autonomy, like so many things have developed that have had ripple effects in the entire practice and entire public health and healthcare infrastructure, when we have had to start to adapt our systems of health to the needs of patients with this unique, serious illness, life-threatening illness needs. And so I think that's what's happening here now. And so with these advances that we have made, and thanks to End of Life Washington and many others, we are at this place where we know that special accommodations need to be met for patients with life-threatening illnesses around their how they want to face their end of life, how they want to address their special suffering needs, and what kind of accommodations should they get. And there's quite a bit that needs to happen, and we've been able to safely do that without tipping the apple cart and and causing all kinds of troubles and with the implementation of aid in dying laws, with the implementation of medical directives, compassionate withdrawal of life supportive therapies in hospitals and in nursing homes and everywhere else. Things are moving, and these were controversial issues years ago. People worried about whether we could do this with people. This is going to, are people going to feel like we're not caring for patients appropriately, or that we're wanting them to just sort of go away, or leave their burden. And you can see whenever you tilt on the side of autonomy and respecting the needs of patients and families around how they want to face death, which we all will face, we end up with a better system. So now the question is, what rights do patients with end-of-life needs have to experimental therapies? And is there a special, like, what kind of public health system do we need in place to meet the needs of patients like this, especially when we have a very active and robust medical industrial complex in the United States and beyond, where all kinds of things are being studied all the time. The FDA is involved in all kinds of applications and petitions from researchers, scientists, developers everywhere. It's a huge enterprise. And many things are coming up in areas that patients really would stand to benefit from sooner rather than later, especially if your time is limited.
Yep.
And so thankfully, right to try laws have enshrined that right, and given walk that path between, okay, well, it's what's safe, what's not safe, what's going to upset the drug development sort of machine, and not keep it from moving in the way that the way we've currently set it up. And I think that's the beauty of these laws, is that they really make that open path and recognize that there's a public health need, that our system isn't just for drug developers, FDA and everything. It's not just for private interests. It's also for the public, and it's for not just to protect us, but also to give us access, especially terminally ill patients, special access. And that is the public health reason that these laws exist. And we're asking the courts and the DEA and everybody to recognize that this is a special law and need. And that's the logic. I just wanted to sort of share that thinking for you. And psilocybin therapy, as Catherine was mentioning, we already know that it's effective with the phase 2 studies that have been done at these various centers in patients just like my patients. So it's only phase 1 studies that are required under the right to try law, but we have the next phase laws. The next phase is already there as well, and they're still in development. So all the boxes are checked. So it's really now it's like, okay, well, do these substances, can they be in their hands now? The answer in my mind is yes. Ethically, we have a moral and ethical duty to once you know something and you have a law and an ability to bring it, you have a moral responsibility to then, to not do that as a form of medical neglect, in fact, because it's you know something that could help somebody and you don't let them have it.
Right.
That's a sort of that's a cruel thing, and the DEA is anyways.
It is. I'm with you. Like, it is really cruel, and so as you're talking, I appreciate like the history, and I was struck, like, we feel like we're on the leading edge, and yet that we've been on this road for quite a while, and but I'm struck that a way to look at the right to try laws, for family members and loved ones is really as a bridge into the type of care that from the past to the present or to the future, where we're imagining really is patient-centered care. And so I want to, Catherine's rejoined us. I want to we have a lot of questions to get to. I want to just briefly, for, I think both of you, but just briefly on it, like this larger question, and then I want to jump into a really few specific ones. I think it's really important for all of us to understand, Sunil, you mentioned this, you referred to it just a little bit, but how might this impact, so like either right to try laws or access to psilocybin impact other palliative options in the future if it were to set a precedent?
I mean, let's see, how would it impact other palliative options? Well, I think this kind of precedent would allow us to treat patients with a cutting edge therapeutic that and ancient too, but a powerful therapeutic that could relieve some serious symptom burdens and non-physical symptom burdens, and potentially even physical as well, actually, based on data on pain and brain injury and psilocybin. So there's a lot of symptom burden and distress relief that could occur for patients and their families. And then if that works that way, then there might be less need for other alternative therapies for those symptoms, whether it's prescription psychopharmaceutical medications, various forms of sedation, palliative sedation, and as Catherine was mentioning, the question around aid in dying, the timing and desire and everything. I mean, so it would impact enrollment in hospice. I mean, it would potentially impact all kinds of things, because you're offering a big palliative measure that, if successful, might take the place of other things, and certainly could work in conjunction with all of those things as well. I think it's a dynamic system, so we don't know exactly what that would look like, but I think
that makes sense.
It certainly will play in those fields.
Yeah. Catherine, would you add anything to that at all?
No, I think that's exactly right. And, we're excited to see, once access is made possible, what that impact will be. It is yet another tool for the palliative care toolbox. And
are there other, kind of diving into some specifics of how this case relates to other things that are happening, is there other entities, law firms, medical groups, hospice pursuing right to try with psilocybin? Well, we're out front on this, and I think everyone is watching with a lot of interest. This is a first try to have application of these new laws. And I think that's why we did see such robust amicus participation, including by quite a number of states. So the interested entities had the opportunity to come in and file friend of the court briefs, and they've done so. And I think the fact so many did so reflect that this is of a lot of interest.
And I would just say, Judy, regarding your earlier question, that even if the main thing for the right to try for this particular patients is really the benefit that will accrue to those individual patients, and that's really all we require, right to try requires of us, is to say that this could help this particular patient with their suffering. And I think I just want to re-highlight that. I mean, yeah, the system implications could be out there, but it really is about the benefit for the individual patient. And I think everybody in hospice and palliative medicine wants the benefit for the individual patient, like the best measures. And my whole field is this field of hospice and palliative medicine has very much always been out front in bringing new therapies to bear in end-of-life care settings, using things off-labelly and other sorts of ways, because we know that's what is demanded. And so that's why it's worth mentioning that we have this big interest group in the the American Academy, which has international membership. So I think that is a clue to me that there's a lot of interest in the medical, at least in the end-of-life care community.
Yeah, good, thank you. We have another question. If the Ninth Circuit remands to the DEA, can the DEA appeal? Yeah, certainly. So when the ruling comes out, it is possible that whichever side has lost can take an appeal. The appellate process would be a petition to the Supreme Court of the United States. Those are fairly rarely granted. And yet here, where there is a federal agency involved,
and states are participating as amici, it's obviously a large and important issue, and it may increase the chance that the United States Supreme Court would take review. So we don't know, but yes, there's also the possibility of petitioning for a rehearing en banc, meaning a larger group of the Ninth Circuit would consider the case. Sometimes parties decide to do that. That happened, for example, in the Glucksberg case. We petitioned for rehearing en banc and were granted it and prevailed in front of the en banc, and then it went to the SCOTUS. So, you know, the tricky thing about litigation is there are a lot of different twists and turns that can happen.
Yeah, so two additional questions I want to get to, and I want to encourage everyone who's on the call there are links in the chat for donating specifically for this cause. You can see the donate here, everything's in the chat there. So I want to redirect people there, but I also have two other questions I want to make sure we get to is, so there were some questions around, you know, how does this relate to local ordinance? Why do we go in this direction, not that direction? And I think a really helpful question for all of us is, how does this suit relate to the efforts that are developing, you know, beginning in Oregon as it relates to decriminalizing psilocybin and providing treatment?
Yeah. Well, so this is confusing. Oregon legalized psilocybin therapy. The Oregon Measure 109 was not a decriminalization measure. It legalizes psilocybin therapy in the state of Oregon. So a legalization avenue by a state is one avenue to reform. There are other avenues, and I see in the chat the person asking about a local ordinance like in Santa Cruz. Those are popping up all around the country, and those are decriminalization measures. And those essentially say that law enforcement will not prosecute crimes in that locality or municipality related to that substance. That's a decriminalization measure. So disambiguating the different kinds of advocacy that are going on and emerging around the country is really important because they're all slightly different. So this right to try effort is trying to take advantage of safe harbor created by both state and federal law. That is a much safer place to be than, say, under a decriminalization measure in the city of Santa Cruz, or even under a state legalization, as has been passed in Oregon. And for someone like Dr. Agarwal, who is a respected clinician, who needs to keep his medical license and he needs to keep his DEA registration to practice medicine, it's not sufficient that there's a lowest law enforcement priority enacted in, say, the city of Seattle. That doesn't meet his needs at all. He needs a full safe harbor under both state and federal law. And that's what we're trying to take advantage of.
Yeah, I think that's really important to, I really appreciate that you, you know, as we begin to wrap up, to really focus in on that is a full, Dr. Agarwal's patients, so as a clinician and his patients deserve full safe harbor. Is that?
Yeah.
Yeah. And that's what is at stake here. And that's what we're doing as far as creating awareness and helping to raise funds. Is we can talk about history, we can talk about law, but this is very personal. This is very personal for Dr. Agarwal, as I'm imagining, as a clinician, and also for patients and family members. You know, so I think we can go really, really big, and we can think about, oh my goodness, look at what this is going to impact. But we're really bringing this back to This is about access. This is about access at the end of life. And this is very personal. And so, Dr. Agarwal, can you speak briefly, just, on one hand, a bit about the data that brings this to light, and also to really wrap up with your understanding of your patients' hopes and even participating in this. You alluded to it, but I think it's really good to, as we wrap up, that we center individuals' hopes. And it is individuals, but it is generalizable to so many others. So
Absolutely. And I mean, there's a few questions here in the chat. I don't know if we're going to be able to get to all of them. I wish we could, but do you want me to address any of these? Like somebody asked, why would we limit the lawsuit to only terminally ill patients? Or are we going to
I don't know that we'll have time. So you can go in either direction. So if you want to answer that.
Well, I mean, I should jump in on that. The lawsuit isn't limited only to terminally ill. The statutes talk about serious and life-threatening illness. So, that's a slightly different definition, and it's slightly broader. And the different state statutes use slightly different language. So if we succeed in this case, the task for clinicians in the various states with right to try laws will be to take a look at the particular language, or have their lawyer look at the particular language in their state statute and get comfortable with knowing which of their patients are eligible. But it is broader than terminal. But having said that, the whole gestalt of right to try is recognizing that it is patients with advanced illness who have limited time, and therefore there's the urgency to enable access to investigational drugs.
Absolutely. Thank you. So just to, I think everyone knows, but let's just sort of, there's been several like highly controlled, so high quality clinical trials at these major academic medical centers in patients with who have life-threatening or serious illness, usually cancer, that have been published over the last like 5-10 years, that have consistently and repeatedly shown significant benefits in the patients who received a 1 or 2 cycles, sometimes 3, but some number of cycles of psilocybin-assisted therapeutic sessions with trained clinicians, with preparation sessions, experiential sessions, and integration therapeutic appointments, then compared to patients who did not receive that or were delayed and received that later on, the changes that were noted in statistically significant, clinically significant changes were noted in multiple metrics related to mood, depression, hopelessness, demoralization, as I was mentioning, suicidality. There's still data being published, but many of the primary, all the endpoints the primary endpoints that they were interested in did bear out. And I think it's interesting to note that this was repeated several times. So people have published summarizations of that. Another study going on right now in one of the cancer centers in Maryland is using another instrument called NIH Heals, which is a healing experiences from all life stressors, which includes psychospiritual dimensions as well. And I'm hearing that there's positive changes being seen in that instrument. Those haven't been published yet. I would encourage folks to go to I was looking for the link for you, but the NIH has done a speaker series on psilocybin in the last couple of months. So this is our tax dollars at work, teaching everybody, bringing some of the leading scientists, describing what's happening with psilocybin. So some of those are already, recordings are online. So I would encourage folks to look at that. So it's exciting. And so as far as bringing it to these individual patients, what this is going to mean for them, I think, I don't know, Erin, if she's not here, but she's been the one that's been most outspoken in several articles that have been published about her own wishes and intentions around this and hopes. And so I would refer folks to look for those articles. There was one in Rolling Stone. There was one recently on Inverse. A few outlets have told, in addition to the original Kaiser and Seattle Times story. So take a look at those and see that. But she talks a lot, if I can just summarize around her sense around making peace with accepting like the significant uncertainty in her life around whether she's going to be able to see her children grow up to their adulthood and have grandchildren. She's dealing with this advanced triple negative breast cancer and has been given a diagnosis where she may have a year to live or less at this point. And so it's around reconciling the stress around that, around what is her purpose of her life right now and how to make meaning out of it right now, and in terms of what that means for her role as a mother. She's described that the hope for her is to leave a lasting impact both for her family and for the larger society, and that's what's driving her. Those are the hopes that she's seeking to realize.
That sounds good. Thank you so much. I want to be respectful of everyone's time, and Dr. Agarwal and Catherine, so glad that you're here. And Catherine, I want to just give you one more opportunity to, from your perspective, just wrap up the implications of this moment, and why, and I will speak to why we're supporting funding for this cause. But I want to hand that off to you, Catherine, for your last thoughts.
Yeah, I mean, I've spent my whole career in advocacy to expand the choices available for patients confronting end of life. And I'm particularly glad to be able to be working to expand choice to include this opportunity for a therapy that has been shown to be so remarkably life-changing and effective in helping patients come to peace with the fact that their life may be ending. And for patients like Erin, she's quite young. She's in her late 40s. And so dealing with that reality at such a young age, as a parent of young children, that is so difficult. And the reset that has been witnessed for patients that experience psilocybin therapy in understanding what their life means and what their death means and the totality of their existence is reportedly quite amazing and life-changing. And it lets those patients live their last weeks and months in peace. Mm-hmm. And that's worth fighting for.
Mm-hmm. It sure is. So your last days of your life, really what we're granting, what we're advocating for is that people's last days can be in peace. We're fighting for just that very basic human right. And so really thankful, Catherine, that you're bringing all of your expertise, your network here for this cause. Sunil, really grateful for your advocacy, both on a personal and clinical level. I think in terms of right time, right cause, like this is the right time for this cause, as End of Life Washington has stepped up and supported psilocybin access as a palliative care tool. We've only received support from the community. Catherine and Sunil, you are the right people to be advancing this cause. And I hope that everyone who's live on this call or viewing it afterwards understands that we have a role in helping to support your efforts so that individuals can have peace and not suffer in their final days. And that is really what this is all about. So I think there's some conversations that are going to potentially go over to Facebook End of Life Washington. I think there's some interest in a webinar part 2, but just out of respect for everyone's time, let's wrap this up. And thanks everyone for coming and attending. Catherine and Sunil, thank you so much for your time, energy, thoughtfulness for this cause. So thank you so much. Thanks everyone for showing up and supporting this effort.
Thanks so much, Judy. Really appreciate it. Thanks all.
All right. Thank you.
Thank you very much. Bye-bye.